Hello. Today we are going to go through some notes that relate to the passage of the U.S. Constitution. So we're going to take a look at the Constitution and how we went from the Articles of Confederation to the document that we use today to govern the United States. So a little bit of background, some information that you already know, as well as some new information. When the quote-unquote Founding Fathers met in Philadelphia in 1787, the issue on the table was revision of the Articles of Confederation, the system of government that was in place. They were sent there to try to make revisions to the Articles. So they're going to meet in Philadelphia. There are going to be 12 of the 13 states represented, and it included 55 men. 25 of these men were slave owners. Most of these people were wealthy planters, they were wealthy merchants, they were college graduates, they had political experience, and for the most part, they were people who were living in larger cities. They were not necessarily from rural areas, so they weren't necessarily farmers, and specifically, really none of them were sustenance farmers who were smaller farmers. And when they arrived in Philadelphia, the major issues on the table were looking at equality, specifically speaking, representation and the issue of slavery, looking at economics, and then looking at individuals' rights. Now, when it was decided that there would be a new form of government, that we would scrap the Articles of Confederation, there are going to be a couple plans that are put into motion. The New Jersey plan, which was known as the Small State Plan, proposed that we replace the Articles of Confederation with a unicameral legislature, meaning one house, just one Congress. And this unicameral legislature would have equal representation in Congress. So very similar to the Articles of Confederation, each state would have the exact same representation as any other state. So this is good news for small states like Delaware. This was supported by the smaller states who feared that if the Congress was based on population, they would lose influence and therefore not be as important as other states. The other plan that was put into motion was the Large State Plan, or the Virginia Plan. And the Virginia Plan proposed a bicameral legislature, so two houses, two Congresses. And both of these houses would be based on population. So the larger states are going to love this because they would receive more representation than a smaller state would. Now, neither the New Jersey plan nor the Virginia plan ends up being adopted, but it does lead to something called the Connecticut Compromise or the Great Compromise. And the Great Compromise or the Connecticut Compromise is going to establish the system of government that we have. A bicameral legislature, so two houses. One house, which is the upper house, is going to be known as the Senate. And the Senate is going to be based on population, will not be based on population, will be equal representation. So the Senate is equal representation in which each state has two senators. Then you have the lower house, the House of Representatives. And the population will dictate the amount of representatives in the lower house, in this House of Representatives. So larger states would have more representation, smaller states would have less. It all depended on the idea of population and how it dictated the number of representatives. Now, on the issue of slavery, Southern states at this time wanted their slave populations to count in terms of dictating the number of representatives they would have in the House of Representatives. Southern states did not want slave populations counted when it came to taxation purposes, so they did not want to be taxed for their slaves. Now, northern states on the issue of slavery did not want slave populations to count for the South in terms of population for the House of Representatives. They did want slaves to count for the purposes of taxation. Basically, the South saw an opportunity that if they counted their slave populations at the time, they would have a higher population. The higher their population, the more representatives they would have in Congress. And the North desperately wanted this to not happen. So they reach a compromise, which is going to be referred to as the 3/5 compromise, which said that 3/5 of the slave populations in the South would be counted for both determining representation in the House of Representatives as well as taxation purposes. So what this compromise essentially does is it creates a legal precedent. So legally speaking, slaves were then considered 3/5 of a human being, which is, of course, awful. But this is going to be the compromise that is established at the Constitutional Convention to try to settle the issue of slavery. So the economic issues at the time. Different states had tariffs on products from other states. And what a tariff is, it's a tax on an imported good. So if you are bringing in, let's say, corn from Pennsylvania, you're trying to bring it into Delaware. The people purchasing the corn, the Pennsylvania corn in Delaware, would then be paying a tax on that corn. So the reason why there are going to be these tariffs on products from other states is it's a way of trying to encourage people to buy products from your particular state. So you could pay the tax on Pennsylvania corn, or you could buy the Delaware corn tax-free without the tariff. So it's going to encourage people to try to just buy within their own states. Paper money at the time was basically worthless. As we know, under the Articles of Confederation, each state was able to print their own money. So it really isn't worth much at the time. And Congress couldn't raise money under the Articles of Confederation. They couldn't actually tax. They could ask the states for money, but the states could tell them no. So the actions that were taken, they needed to make sure that the powers of Congress were strengthened, especially in terms of the economy, and they wanted to be able to limit the power of states in economic issues. And in terms of individual rights issues, some things are going to be written into the Constitution that are going to be meant to protect the American people from abuses of power from the government. So, for example, prohibits the suspension of writ of habeas corpus. Habeas corpus basically means that you are told, if you are put in prison, if you are arrested, why you are being arrested. So you can't be put in prison for no reason whatsoever. You need to be able to have a reason provided to you why you are put in prison. No bills of attainder, basically meaning that Congress can't actually try anybody. Congress is not a judicial body, so there are no judges, no juries. So Congress is not responsible for charging crimes. Then you have no ex post facto laws. So what this means is if something is legal when somebody does something. So let's say in the state of Delaware, it is legal for you to steal a candy bar, for you to walk into a store and take a candy bar and walk out. If a law is then passed saying that it is illegal to steal a candy bar, that means that you cannot be tried for that crime if when you did it, it was legal. So if there was no law in place when you stole the candy bar, they can't go back and charge you for a crime because it is now illegal. So Congress cannot pass laws that would punish people for something that was legal when it was done. The Constitution is also going to prohibit religious qualifications for holding office. So you can't be told you can't be a part of the American government because of a religious reason. So trying to separate church and state. There's going to be strict rules of evidence for conviction of treason, including the fact that in order to be convicted of treason, there needs to be at least 2 witnesses against you. So it doesn't turn into a he said, she said type of situation in terms of treason. And it'll also guarantee a right to trial by jury in criminal cases. So the idea of a jury is going to become a huge aspect of the American government. This is all going to be based on something called the Madisonian model. And it's going to be named after James Madison, who's considered to be the father of the U.S. Constitution. So Madison is going to be trying to design a system of government that will protect against tyranny. So he is going to propose a government that has a lot of different systems to try to prevent tyranny, including separation of powers, checks and balances, and establishing something called a federal system. So some of the aspects of the Madisonian model, you have the Electoral College, which selects the president, and the Electoral College is selected by state legislatures. So the president has 4-year terms. The president nominates members of the judiciary branch, the judicial branch that has lifetime terms. Those judicial branch members are confirmed by the Senate. Senate serves 6-year terms, and the House of Representatives serves 2-year terms. And all of this is ultimately decided by the voters, whether they elect a president, whether they elect members of the House, members of their state legislatures, members of Senate. Basically, the American voters, the American people, are involved in different aspects of government. So here you can see some of the different checks and balances that exist within the U.S. Constitution, such as the presidential veto, such as the fact that the president nominates judges. The Supreme Court can decide whether or not something is unconstitutional. So we have all kinds of different checks and balances within our Constitution that try to limit one branch from becoming too powerful. So under the Madisonian model, the United States Constitution falls as a constitutional republic. A republic being a form of government in which people elect their representatives to govern them and make laws on their behalf. Now, when folks leave the Constitutional Convention, the document was approved, but it was not approved unanimously. It had to go through a ratification process. And this is going to lead to a debate between 2 different groups. The Federalists, who are going to be very much in favor of the new Constitution, and the Anti-Federalists, who are going to have some serious concerns about the Constitution. So in order to convince people to ratify the Constitution, there are going to be essays that will be written called the Federalist Papers. Now, the original plan was to write 25 essays. In reality, the 3 men who write the Federalist Papers under a pseudonym, and the pseudonym being Publius, are going to be Alexander Hamilton, who's going to write a majority of them, James Madison, who will write a great deal of them, including some of the most influential, and then John Jay, who is only going to write a handful of them. Some of the really important Federalist Papers are going to be Federalist number 10, which is going to be written by James Madison, and this is going to address the idea of factions. Factions is a term that is used synonymously nowadays with the term party. So they're very similar to political parties, where you have different groups with different ideals who are not necessarily in alignment in terms of what they believe. So he's going to, in Federalist 10, discuss how we should be wary and concerned about these factions. Federalist number 39 is going to define the term republic in an American sense. Federalist 51 is going to address the idea of checks and balances and separation of powers within the government. And ultimately, they're going to try to convince people to ratify this Constitution. So some of the differences between the Federalists and the Anti-Federalists. Anti-Federalists tended to be small farmers, laborers, owners of smaller businesses, And they're going to really want strong state governments, a weak national government, very similar to what we had with the Articles of Confederation. They're going to want direct election of officials, so actually voting directly for the people who rule you. Shorter term limits, rule by the common man, not these elite, wealthy individuals, and really are going to push for things like individual liberties. And some of the major advocates for this will be people like Patrick Henry from Virginia, or Thomas Jefferson, or George Mason. The Federalists, on the other hand, are going to be large landowners, wealthier merchants, professionals, those who have strong educations. They're going to be in favor of weaker state governments and a stronger national government. They are going to want indirect election of some officials. So, for example, the way that senators used to be elected was people within states would elect people to their state legislatures, so to their state Congress. And then state Congresses would elect the senators to go to Washington, D.C. So before we changed this constitutionally, the people living within the states would not directly vote for their senators. They would vote for people who would then vote for their senators. So this is going to be the idea of indirect elections. They're going to advocate for longer terms in office. They're going to advocate for government by the elite. And the Federalists are going to basically feel as though you don't need to list individual liberties because government would not be violating them. And some of these supporters of the Federalists would be Alexander Hamilton, James Madison, and John Jay. So the compromise they come to is to put together 10 amendments to the Constitution that would help to establish some individual liberties. And this will be known as the Bill of Rights. George Mason is also referred to as often referred to as the father of the Bill of Rights because he will be one of the major advocates for it. So the formal amending to the Constitution, the process itself, essentially you need to have a proposal to a proposed change to the Constitution needs to be approved by 2/3 of both the House and the Senate. And once that happens, it needs to go to the state legislatures. If 3/4 of the state legislatures agree, then an amendment to the Constitution is formally passed. You can go through a process where you call another convention. It's really just been done once in American history, but that's also an option. But traditionally, you get 2/3 of both houses of Congress to approve the change, and then 3/4 of state legislatures to do that. So this is just a little bit about how our U.S. Constitution is going to be formally ratified and put into place. So you will be using these notes to help discuss the similarities and differences between our U.S. Constitution and the Articles of Confederation. As always, if you have any questions, please feel free to reach out to me via on-campus message, via email, or talk to me in our Zoom class. But aside from that, good luck, and please let me know if you have any questions.